So I would like to start probably with Anna Sophia, then with Christina, and also the rest of the panelists. So go ahead, Anna Sophia. Yeah,
This?
I think it works, or this works as well.
Wonderful. Perfect. Well, thank you, Anis, and thank you for inviting me and for hosting and providing us with such interesting discussions. I will start with the support that the Portuguese Competition Authority, as other MCAs, have provided to what is pursued by this initiative of the Commission, which is to have more vigorous, robust, and effective enforcement of 102. We think that it's absolutely crucial that this is so, and we want to keep being part of that. Maybe today more than ever, not only in order to protect consumers, but also because active 102 enforcement is crucial to ensure that there are sectors that are freed from competitive bottlenecks, because it is important, together with other policy instruments, to ensure that resources are driven and investments are driven to free and undistorted competitive markets, rather than being driven by the opportunities, the business opportunities that mature and uncontested market power may artificially create. So we think that is very important, and also taking into account all the externalities at the macroeconomic level that have been pinpointed, for example, in the recent Draghi report of the importance of effective enforcement of 102 and of competition policy in general. So that is the first point and the first part of the support. Now, then the second point that I would like to make is that in order to discuss the guidelines, we must bear in mind the circumstances in which they are produced, which I think are a bit of a crossroad between future and past. First, the debate and the Commission had to take into account and take stock of all the case law, which we know sometimes not to be coherent, which we know that sometimes can be highly insightful and provide a lot of understanding to the economic theories of harm, but sometimes can also be quite narrow and outdated. Then the second point is that the guidance and the guidelines want to provide legal certainty and provide limiting principles as to what firms and businesses should see as potential infringements to competition law. Now, the third point, which I think is also very important and understandable, is a concern which I think, as an enforcer, I fully understand and share, which is the concern that you can somehow crystallize and have very close-ended safe harbors that may leave out conduct that may not at the first sight seem like an infringement or tick the box of legal tests, but in the end they are. So I think it is these three elements that are relevant to take into account when looking at the guidelines. And now, okay, so we want, and I think that's also what is meant by a dynamic and workable approach, because this is very difficult when you have so many dynamic markets, when you can see new strategies being adopted by firms. So it is challenging, and I think this is the background for the discussion that I would like to make in what follows. So now I would like to address some of the comments of the spotlights that have been around the discussion of the current draft guidelines. Some might bear some more robust foundations, some others might not. Now let's take one of the comments that has been thrown at the draft guidelines, which is that that it lacks economics. And there are some more solid reasons that can fundament that argument, but there are others that, in my understanding, they do not. Some people have argued that this lack of economic is due to the introduction of presumptions, and I think that is highly misleading. So we fully support the introduction of rebuttable presumptions in the guidelines. We think that arguing that an effects-based approach is necessarily one that goes case by case, building everything afresh, as if there were no established economic knowledge in case law, would be a waste of time and a waste of resources. So we think that these rebuttable presumptions, based on well-founded economic theory and experience, that work for triggering bird shifting between the parties and the agency are highly welcome, and we were very happy to see those in the guidelines. Now, another point on this argument that there should be more economics in the draft guidelines has to do with the debate around the as efficient competitor test and the as efficient competitor principle. And on that regard, I think there's important improvements in the guidelines. And the first one that I would like to point out is that the guidelines are very clear on to which conduct and which cases the as efficient competitor test can be useful and those for which it cannot. And I think that this is an important clarification, particularly bearing in mind that there's some views of some people that try to equate an effects-based approach as an as efficient competitor test for all contexts and all situations. So I think that was very important. Of course, then there are the concerns that have been raised with the fact that there's no safe harbor for the as efficient competitor test when you have price above average total cost. That even in terms of the as efficient competitor principle, there's one of two sentences, I think paragraph 73 is one of them, in which there seems to be assume the possibility of departing from both the as efficient competitor test safe harbor and both the as efficient competitor principle. And I think looking at that, we should think, well, we know that these are not perfect principles, and we know that the as efficient competitor test is not always useful, and you know that it is inherently a static test and that it might not capture all the situations in more dynamic settings. Okay, so there are important situations in which there are reasons to depart from them. But in order for us to have ownership on how to determine which situations, I think the guidelines could think about the option of scoping these situations by providing a rationale of when can an agency depart or the Commission depart from the as efficient competitor test safe harbor and the as efficient competitor principle. And I think that providing this rationale would be very important, so not only for providing a legal certainty to firms, but so that we, enforcers and Commission, we own what path is going to follow there. Now, then, of course, a reaction might be, well, but, if we have too close safe harbors, then we are going to run into trouble because we are going to be faced with situations in which they are not matched. And, we can scope it. But by scoping, you're introducing rigid limits. And I think that we can have a middle way there, which is by providing examples that do not close the door to everything. They're providing examples so that you can transpose to who reads, to the business, to courts, what is the rationale that you are going to apply in order to identify those situations in which there are exceptions. Now, another point that has been raised very often, and that relates to this one, is that the guidelines should have more theories of harm, that the concept of theories of harm is not explicitly spelled out in the guidelines. And that is one which I think we should listen, right? And I think if there's one thing that effective enforcement of 102 is about being built on robust theories of harm and narratives that we can understand that can make sense of all the evidence in a case. So maybe there is also room for improvement there. And finally, on the consumer welfare, I always thought that this was a strange discussion because, there's a lot of people that try to pin down consumer welfare to prices. I never understood it. I cannot understand how somebody can understand it like that. But I think that the Commission did very well by clearly stating at the beginning that consumer welfare is not only about prices but about quality and choice and innovation. And with relating to that, I think that paragraph 51, which reconducts the notion of competition on the merits, which for economists can be a bit of a strange animal or a bit of a difficult animal to define, the fact that this paragraph 51 somehow redirects that concept to consumer welfare, I think it's something that could be clearer and more clearly stated in the guidelines. But, this is just opportunities for
Although
improvement.
they don't mention consumer welfare, they prefer
Consumer benefits.
Anyway, some might even ask, if this should be the only focus. Christina, the floor is now yours. Go ahead.
Okay. Let me start with something a bit controversial for a change,
Great.
which is, as you know, I am a big proponent of disclosures. I think disclosures are a problem in our industry. I think that what Jonathan Kant has said in New York and before that in Oxford, you were in the same room, is a very major issue, and people don't know how to disclose. Frankly, to show up and say, I work for one side and the other, and therefore I'm okay, I'm neutral, isn't good enough. Disclosure works as follows. You have to tell the audience, out of respect for them, who you're working for, and name names. And if you cannot name names, don't come and speak at conferences, because that's a fundamental thing. So in my case, I say that every time, but I want to be absolutely totally clear. I have worked against Google and Facebook, both for private clients like Kelku, like News Corp, and for agencies. I worked with the FTC and I worked for the state's attorney general. I have worked for Amazon, Apple, Microsoft. I worked for Uber. I worked for Netflix. I do not work for any of them anymore. So let's be very, very clear about that. I'm not being paid by anyone. So when I'm speaking now, I don't represent anyone. And I care to say that because given I'm an unusual animal, people don't know quite what to do with me. Usually, big tech operatives say that I work for the Russians and the Chinese. This is their line. Because I worked for Android, on Android for Yandex all those years ago, and I did a small case in China for, I don't know, whatever, against Tencent, which never went anywhere. However, I also hear, and I'm sorry to say, from people in the Commission who go and say I'm an undercover lobbyist for Amazon and Microsoft. This is false. Bring the receipts. If you have receipts, bring them out, but I'm not a lobbyist and I don't work for any of those. So take it to the ranch, because I'm hearing things that people are saying about me in DC that are not okay. Okay, so I think that is clear enough, I hope.
It is, I think.
I think so. Let me just go into the substance. So I really very much like the approach that François Belli took this morning, because of course, like him, I'm a veteran, and so many people in the room were not there when I started this, but I think it's useful to put a little bit of a historic perspective about how we got here. Even before getting there, I like, as an economist, to think about what is the ultimate empirical relevance of the things we're discussing, because I do accept that for people who are academic lawyers, the issuing of a new guideline is the most exciting thing that could ever happen ever, and you're going to spend the next year poring on every paragraph and do redlining and compare to what came before and just get super excited about it. I also can see that for consultants and lawyers working in cases, it could be a point of excitement because you want to say something. That said, when you look empirically, and this is no news to people in this room, but at the number of cases that are there, I looked exactly at the number of cases in the last 5 years, 2019. We have essentially had 2 Apple cases, we had 2 Amazon cases, we had Google Ad Tech, which is asleep, or at least in limbo. We have Facebook marketplaces, which is in limbo, which we still have the Teams case, Microsoft case, which is kind of trundling along. And then you have 2 cases on pharma, you have Qualcomm, you have Broadcom, you have Intel, and a couple of cases on energy, right? We have about 15 cases in 5 years. It isn't a lot, right? So in terms of its empirical sort of relevance to the rest of the economy, it's very little, frankly. I accept that the NCAs are doing lots of cases locally, and I take the point. But personally, to get out of bed, I don't get out of bed for 1 or 2, because I don't think it's that exciting or relevant empirically. That said, let's kind of talk about briefly how we came to this point. So I think the guidance paper, as Jean-François Belli was alluding to this morning, was the most successful lobbying ever by economists in the early 2000s, right? We were all out there lobbying like crazy. Me, Jorge Padilla, and Simon Bishop, we were the big beasts at the time, and we were lobbying for a more economic approach, because we were so sick of the Commission being so formalistic. And with good intention, at least for some of us at the time, because we did think that there was merit in doing something that had more structure, that had more methodology inherent. More economics was going to mean, scientific method, except that what really inspired us at the time and was embedded into the kind of thinking at the time was a deeply Chicago approach that we had at the time. We had the terror of the type 1 error. The whole drive was we cannot over-enforce. We need to have economics because economics is going to be effective in discerning between cases that are actually efficient, where the conduct is efficient and when the conduct is anti-competitive. So type 1 error was the leading light. Efficiency was the North Star, because we were all saying, of course, this conduct can have efficiency justification, and we cannot do censoring of a conduct that may ultimately, yes, foreclose some people, but they are inefficient, right? And if they're inefficiency, they deserve to die, because we only care about people who are efficient, don't we? And so this whole philosophy, let's not beat about the bush, is what animated us at the time. It was a hardcore, neoclassical, neoliberal philosophy of a Chicago school derivation. And so we even thought, of course, we have methods, we have ACT, we have as efficient, has anyone been in a room where ACT is done? Well, I have. It is snake oil, it's cooking the minestrone. You take the data, you slice it in 17 different ways. The lawyer says, how's it looking? And you say, it's a little tight. If the commission changes 2 assumptions, we fail. Go back and cook it a bit more, right? Until we have it. Has anyone got that this is the reality? This is what we do in GAPIs, this is what we do in economics. What do we think we do? We managed to bamboozle the entire bubble thinking that we do highly sophisticated analysis. This is snake oil from morning to evening. So, that said, I think it is inevitable that given that background, when people kind of listen to economists and then try to apply it in practice, they go, well, this is kind of a nightmare, right? And no doubt you have things like Intel that fall over the moment you kick it. But what a surprise, it was all with spit and straw. I mean, the whole thing was inevitable. And then we ended up in this world in which we economists continue to pursue this kind of narrative that we've got the narrative to push back. So we've got an app for that. Every single form of anti-competitive behavior, I can give you a exculpatory narrative, right? This is efficient. Exclusivity is efficient. It's competition for the market. Are you kidding me? This is the stuff we sold successfully, but it is mostly a lie. We made it up because and people even listen to us. So it's no surprise that, after this time, people are saying this is kind of not helping us bring cases. It is not helping us winning cases. It is not leading to over-enforcement. If anything, there is massive under-enforcement here. And so we need to review it. So I will try and wrap up. But essentially, I understand that, Max has got a hard job and has to somehow rewrite what was there. The reality, though, is that we're trying to kind of distill some general principles into guidelines that are incapable of being precise. Because what does competition on the merits mean? What does something is likely to affect the competitive process mean? Has the potential to affect the competitive process? What does that mean in abstract? Do I know it when I see it? Yeah, I want to see the internal documents, and I can tell you if I think they were up to something, because that's what matters. I can see that you want to enunciate this general principle, but I don't know how you operationalize them behind. And so I don't get the whole knick in a twist around this change of phrase, this change of phrase, this change of phrase. Like, whatever does it mean? I don't know. It didn't mean anything before. It doesn't mean very much now. So I can't tell you that it is very, very definitive. And finally, so yes, we roll back some of the strongest kind of statements on the importance of economics. Rightly so, because of what I said before. We don't have the answers. Many of this stuff is made up. We are selling it, but it is made up. Yes, we're introducing presumptions for the reasons that Anna Sophia says. I'm in favor of it. Of course, we need to have some presumptions. We can't have everything as a case by case. And yes, I find it laughable when people say by moving away from sound economics, we now made everything less predictable. Are we serious? Sound economics what? The stuff I just told you, the stuff that we do, the snake oil that we cook in the kitchen, is this sound economic? Is this the sort of neoliberal ideal that we want the world to believe? We know what really is foundational. So I think I'm very troubled by that kind of comment, but I also understand that it is inevitable that people of a certain persuasion will say sound economics is important because that's what we're selling at the end of the day. I think what we're missing is a much more holistic view of conduct. I mean, if you read some of the complaints that are being put forward by, DOJ or FTC against Amazon or Apple, etc., they don't kind of narrow down on a test. They kind of say this is a frigging ecosystem, it's huge and it's a problem. And you have multiple set of conducts that are problematic and complement and strengthen each other. Well, that I kind of get, and that is important. And final point. Exploitation is something that we've all mentioned, all the other speakers have mentioned before. I remember asking Max this question a year ago, and he was like, there is no case law. I get it, but the reality is that we're doing dumb cases because we don't have exploitation. I worked on the 2 Amazon cases, on the 2 Apple cases. Guys, the issue there is extraction, is not exclusion. Amazon was not an exclusionary abuse case. Where is the Microsoft blueprint? Amazon buy box, Amazon data, there was nothing exclusionary. The cases were dumb. And that's why the commission wrapped them up, because they were going to lose them in court at the end of the day. I worked on those cases, so I know. But they were not exclusionary. Apple, Spotify, in the end, because of the Dutch authority, the commission veered into exploitative, but it went along for 7 happy years as an exclusionary case. And you sort of say, well, how is this exclusionary really? It's not kind of fitting. Okay, so I think that needs to be the next step. Okay, I'll stop here.
Well, thank you, Christina. That was fascinating. And of course, you put a point on the idea that there is an issue about empirical issue. I mean, this is over enforcement, under enforcement. You actually raised the issue that might be under enforcement, and I think I agree with that. And of course, the question about most holistic perspective. I mean, the idea that we don't really talk about ecosystems, we don't actually have these theories of harm. All right, let me now pass the floor to Martijn for his comments.
All right, thank you, Hannes. And so this is going to be a little improvising, but I think there is a lot to say and a lot to discuss. And maybe to start with your introductory point about under-enforcement. I think I wholeheartedly agree that there is under-enforcement in the Netherlands. I'm not talking about other jurisdictions. I'll focus on the jurisdiction that I'm responsible for. And there is under-enforcement. And there are good explanations for it. By the way, I'm not the only one who's saying that there is under-enforcement. The Ministry of Economic Affairs ordered a study by Tilburg University, and they did a review of our 102 cases and the Dutch equivalent, which is exactly the same wording as 102. And they also acknowledge that there is under-enforcement in the Netherlands, both in the private enforcement and in the public enforcement. And the reason, just to give you an illustration of why there is under-enforcement, it's not that we don't bring cases, but we lose all cases. I think over the past 25 years, we've only won 1 case on abuse of dominance. We have now 2 pending, so there are good hopes. We have an excessive pricing case, and we have the Apple case in the courts. But getting cases past the courts is not easy. And why is it not easy? Because the judges, there are good judges, knowledgeable judges, but I think there are a couple of reasons why they are very difficult to pass the court. And first is that there is, even nowadays, a lack of a common view on and confusion on what the appropriate legal test is and what the evidence is that is needed to meet the test. And that confusion, is sometimes solved by a case by the Court of Justice, but then reading the commentary of the cases, reading a different judgment, it is very hard for a national court to distill a kind of a common view on what the appropriate legal test is and the necessary evidence. Second problem is that the standard of proof is high. We are in a quasi-criminal situation, so that means that the test, different from mergers, is that, whatever you want to phrase it, it's beyond reasonable doubt. That's a pretty high standard, which is completely defendable for criminal cases, but in competition cases, it's hard to meet. There is no hard evidence, and there's no dead body, we have no DNA, there are no fingerprints, there's no weapon. It's all, it's interpretative evidence. And that's why I think your snake oil comes in for many judges, is that they grapple with it. They want to find the hard evidence. And then there is a magician that comes in, a snake oil dispenser that comes in with the idea, listen, I have hard evidence. And judges tend to believe that. And then they look at, there's one expert says, no, this is really hard evidence. And of course, then there is another, an agency expert that says, no, it's not hard evidence. And then it comes up, which expert the court is more likely to believe. And when it's beyond reasonable doubt standard, it happens from time to time that the court kind of takes the side of the defendant in the eye where, we have to protect the defendant against the mighty sword of the government. Third element why it's so difficult to try these 102 cases is that contrary to a cartel leniency case, there is no cooperating witness. We have no insider that whispers in our ear, it's like that, and you should interpret the document in this way. So yes, we have a complainant, from time to time a very active complainant, but nothing compared to a good leniency whistleblower that is really able to tell the intricacies of the cartel and how to interpret secret words within the minutes of a cartel meeting or secret messaging between members of the cartel. And finally, it is important to realize that also contrary to cartel cases, there is this one dominant company of which suppliers are scared, of which customers are scared, and competitors are scared as well. So we are often faced with the fact that, yes, complainants or companies are willing to share evidence and give details to us, but only on an anonymous basis. And if that is the case, we cannot use it in court. So that makes Article 102 cases extremely difficult, and why there is serious under-enforcement in the Netherlands. And the fact that there is serious under-enforcement is something that we should take into account and take seriously for two reasons. The first reason, of course, is that it leaves kind of consumer harm unsolved. So there is serious consumer harm to which a competition authority basically does not act against. But secondly, there is a huge gap between the expectation of the public of what competition authorities can and should do and what competition authorities in the real world, faced with these challenges, are actually doing. And this gap between expectations on the one hand and the reality of authorities on the other hand is going to clash. And in that gap, there will be actors trying to fill that gap, and I'm not sure that is good for the entire structure of competition enforcement. So, of course, I want to also give some happy notes. It's not only that, and I think the guidelines, the draft guidelines of the Commission, are absolutely a good and a right step into the direction of solving the problem of under-enforcement. We like workable, effects-based. Who doesn't? Everyone loves something that is workable. We love the presumptions, maybe some do, but the problem is that the guidance requires probably on a lot of topics even more guidance, and not for the competition community, but for the national courts. And therefore, I hope that the Commission, in this kind of a stakeholder inclusion process, will test the draft guidelines with the national courts. Because basically, if they understand it and draw the right conclusions from the guidelines, then it's going to work in Europe. If they are still looking for snake oil sellers and are confused about the test and the evidentiary burden, then I think we need to do a better job. Second, what is important, it's already been said, is that we do need guidelines for exploitative abuse. And I do understand, and here the Dutch Competition Authority and the Commission have a fundamentally different opinion. We see ourselves as, kind of also a participant, a shaper of the law, not only through cases, but also through guidelines. So we are more than happy to issue guidelines on how we interpret the law. And then, of course, always the final word is for the court. But we are not like judges who only speak through judgments, but we also speak through guidelines. And we have an open consultative process, everyone can comment on it. And I do hope that the Commission, is maybe with the experience of the sustainability paragraph in 1013, is maybe also taking a further step into drafting guidelines for exploitative abuse, because it is going to help national courts. The authoritative voice of the Commission as the guardian of the treaty is important and is an important voice in national cases. Two final comments. One is that, of course, this all does not solve the problem of the standard of proof, the beyond reasonable doubt. And therefore, I was excited to read in the Draghi report another call for a new competition tool. Because I think many of the issues that we are addressing are actually not quasi-criminal behavior, but are regulatory issues, are issues of markets who are not functioning well and that need to be solved. Not because someone infringed the law. I mean, there are cases where there is a clear infringement, but there are also many cases where I think we need a tool, a non-punitive tool with a different standard of proof to address market failures in a market. And the new competition tool, as has been developed in the UK and now been adopted in Germany and in Italy and in other countries, is going to help to solve this particular issue of under-enforcement, not necessarily by bringing more 102 cases, but by bringing 102 cases and NCT, new competition tool cases. And then finally, a call to the kind of the wider community here, the unusual suspects in some cases, please raise your voices. We as national authorities, same for the European Commission, are faced with an army of lawyers and economists that have as their profession, and I was one of them myself, to defend companies against actions of national authorities. We are faced with legal scholars, academics, who are, I wouldn't say obsessed, but who are very focused on freedom to contract and legal certainty and all those also very important things. But we also need a voice from society that says, speak up, competition authorities, do something, address these issues that real people in real life are facing. And that's the final call to the unusual suspects to also speak up in this debate. Thank you very much.
Excellent. Thank you very much, Martijn. Also, I think you raised an interesting issue that we could have discussed earlier on. Maybe you have time to comment on that, which is the relation between, the court at the end, who is actually the final interpreter of the treaty and the guidelines. I say that because in Forum a couple of weeks ago, a judge of the court raised the issue of why the Commission needs to adopt guidelines. We actually drafting the law. in a way that I found quite categorical, but I think I'll be interested to hear more from the Commission, also from the colleagues, about that, because at the end of the story is also that the court is not feeling that this is a sort of power grab from the Commission in terms of their role to interpret the law. And of course, about the standards, I agree with Montaigne, although this is something that depends on the member state to a certain extent. Balanced probabilities can also be a way to think about the standard here. Some of the states don't even have the concept of standard of proof. It's in team conviction of the judge, so there's no really standard. Damien, the floor is yours now. Share your views.
Thanks a lot, Yanis. Very happy to be here in such a good company. For the journalists in the room, don't attribute anything I say to the gentleman on the other side of the table, whose name sounds familiar to mine.
You're both very tall as well, so that doesn't really help.
Now, I'm going to give you just a really view from the trenches, right? From the trenches of the Belgian Competition Authority, and obviously I'm going to echo a number of comments that have already been made. To start with, from the trenches, for sure, the guidance paper certainly increased the justification cost, and you can lose a case, because of the heavy justification cost you have to meet, and so very frustrating when a 102 case, you win it on the facts, but you can actually lose it on the law, and you can lose it simply on the evidentiary requirements and whether or not you meet. What is the judge interpretation or appreciation of what the evidentiary burden is or should be. Now, from the trenches again, I think the Commission, Max, your team, congratulations for having engaged in that exercise. It's a difficult one. It's also because with the policy brief, you had sort of put a marker at the point which was. Somehow, at another, went in another direction than the DCJ case law at the time, and so it's both courageous, it's complex. As national competition authorities, we're certainly here to support, to help, and clearly the draft goes in the right direction towards a more workable effects-based approach. What I see as the main strengths of the document. They all revolve around, the concept of causality and evidentiary requirements and the clarification that the draft brings in that regard. And it really anchors, the idea that, to find an abuse, you have to look at the reality at the time of the facts, right? And not consider some re-engineered, ex-post virtual reality, cooked in a lab. So I think that is a very powerful message. Among my favorite paragraphs of the draft are 62, 65, and 69. The assessment of whether a conduct is capable of having extraordinary effects is based on the facts and circumstances existing at the time when the conduct was implemented. The actual or potential exclusionary effects identified in the analysis need to be attributable to the conduct at issue. However, the conduct does not need to be the sole cause of these exclusionary effects. The assessment of whether a conduct is capable of having exclusionary effects must take into account all the facts and circumstances that are relevant to the conduct at issue, and there may be some clarifications along the line suggested by Simon, on the importance of qualitative evidence could certainly, help as well. Now, obviously the presumptions, that's a really important step in the right directions. My little concern is that these might be relatively soft presumptions and also internalized presumptions. So I think the risk, is that there is this form of generalization of, how the Intel judgment sort of conceived the sequence of the analysis, right? And that, once the presumption is somehow flipped, the justification costs are huge. And so if there is a way to try to mitigate that risk, I think that's worth, trying to reflect on. And obviously, it's very helpful, but it was already the case in the guidance paper, but to have this reference to naked restrictions here in a much more, elaborate way, but still, I think it's quite narrow, it's very prudent. There's probably scope to enlarge that category. I don't know why predatory pricing below average avoidable cost is not in that category. I don't know why, you don't take, the Super League judgment into that category and try to, it's not obvious, but try to characterize that practice as a naked restriction as well. Now, what I see are the three maybe the weaker points. Max knows it. The first one is that I personally, but it's a very personal point, and obviously everything I do is personal, but I still struggle a bit with the dichotomy and the interaction between departure from competition on the merits on the one hand and capacity to produce exclusionary effects on the other hand. Paragraph 46 says they are conceptually different. I still struggle with that. I think, probably there is still a bit of work to be done to better articulate, the two limbs of the test. And my fear, frankly, is not a theoretical one, or is a very practical one, is that I really want to avoid that this sort of two-limb test, that dichotomy, backfires on enforcers. Because if it gets legalized, right, if in court you end up having to argue about, have you met the first limb, have you met the second limb? But you actually argued this in the first limb, so you haven't proven the second limb, I see that happening. I see it coming, and I think we should really try to avoid that. The second weaker point, I think I've already mentioned it, is the risk of generalizing the Intel approach. Obviously, also linking presumptions with categories means that we're going to have to litigate whether you fit into the particular categories, the particular boundaries of the practices as they've been defined. But that's fine. We've been there. But that's something to keep in mind. Personally, also, I would have liked to see a bit more language on the importance of protecting less efficient competitors in certain cases. I think, and on the circumstances where that actually is important to protect competitors in order to protect competition. I think that's something we could also try to reflect upon. And otherwise, I echo also what Martin has just said. More illustrations that could speak to the minds of lawyers, to judges, especially. Speak to judges. I think that could be certainly helpful. And then obviously you sort of felt you had to take on board all kinds of ECJ language, which to me, sometimes remains a bit of a mystery. But, I think you've done a great job in trying to make sense of it. The missing elements, the first missing element, one that is dear to my heart, is that there is nothing, or almost nothing, about abusive acquisitions in the draft. Now, I think after Towercast and Illumina, I think that's really something we should reflect upon and consider. And there is a clear mandate. In Towercast, the court said we have to do something to close the gaps in the system of protection against distortions of competition, which may result from corporate reorganization. There is a mandate there, and I think, by the way, the reinterpretation of Article 22 was a very elegant attempt to solve a real problem. It's just a pity, it essentially felt outside of the boundaries of what was apparently acceptable. Now we have to find other ways, and maybe here there is an opportunity also to try to clarify what is fundamentally an exclusionary abuse. You just buy your competitors, the last remaining competitor, whatever. Second missing element, these mixed exploitative exclusionary abuses. Also in relation to labor markets. I'm not disclosing any secret here, but this is not easy and we're struggling to try to articulate a coherent theory of harm when it comes, for example, to excessive non-compete covenants, right? Which are in a way exploitative for the workers and can be exclusionary for competitors. And I think I'll leave it here. For sure, the guidelines are going to have an influence, a strong influence about how we run cases at national level, and how judges sort of review them. As I can tell you, as we speak, we have colleagues trying to see how to already integrate, the approach of the draft guidelines in a statement of objections that we have to address. And just to echo my little concern about the two-limb approach. I think colleagues are a bit struggling about how to articulate these two limbs without shooting ourselves in the foot, and trying to anticipate a bit what the likely defense strategy would be.
Well, very, very good point. And actually, on the dichotomy, I mean, I was surprised to read the statement that this is cumulative, and then the other one that these are conceptually different. Because for me, I will agree, these are conceptually different, but that will lead me to the conclusion these are alternatives, not cumulative. And I think this is compatible with what the court also says in AdSense. So, to a certain extent, I think they are conceptually different because, a naked restriction is not competition on the merits, and you don't have to talk about capability to exclude or produce exclusionary effects because it's not really about the effects. So for me, if you are thinking that these are conceptually different, then the logical conclusion is that these are not cumulative, but alternative. So the or instead of the and. That's at least my position. Okay. Damien, the floor is yours.
Thank you so much. My apologies, I'm not sure that I will manage. Let's not destroy the whole thing. Sorry for not being able to attend panel 1. I had to be in a call, unfortunately, but I'm happy to be given some time in panel 2, which I will not abuse. So I will try to be short, and I will try to avoid saying things that have already been said. So, first of all, 15 years ago, I would have been highly excited, or 20 years ago, I would have been highly excited by these draft guidelines, because at the time I was an academic, and I really enjoyed these things, and I would have read every single word and questioned myself about what it meant, and I would have been critical as well, because, the goal as an academic is to be critical, so I would have found many flaws in the document and write about it. Now, 20 years later, after 20 years of practice, I'm much less excited about these documents. Right. And it is the case for several reasons. I think the first reason is that I discovered, being a practitioner, that whether this word is used or not used doesn't matter the least, most of the time. Because what matters are factors such as whether the regulator has time and is motivated, whether it is able to act speedily, and whether you will not waste 3 years over things related to the rights of defense, which have gone completely out of control, which means that, there are so many ways to derail cases, derail litigation, that it becomes very, very hard to achieve anything. Okay? So my focus is slightly different these days. Although I read the guidelines, I also read the harsh criticism about the guidelines, that it's not in line with the case law, the two-step process doesn't work, it's a betrayal of the guidance paper. But of course, these comments are made by people who talk to an audience, which is their clients, right? So we always need to take them with a pinch of salt. Now, as far as I'm concerned, I think it's a good document. I think it's well written. I think it's quite clear, and therefore, it will definitely be useful from an educational perspective. I think it's going to be a very handy tool for national competition authorities and courts, and therefore, I'm glad that it exists. Now, the reason what I'm, of course, disappointed about is not about the guidelines themselves. It's just because it's not what we need, right? So, as a practitioner, disclosure, I work against big tech. This is what I do. I file complaint, I sue them for damages, I write papers they don't like, and I try to annoy them as much as I can with great pleasure. Okay, so this is basically what I do, and especially because there are few on my side, so it's particularly pleasurable. In other industries, I do defense as well. Okay, so I can do defense, but in tech, I'm only on the claim and on the complainant side, and we know that Article 102 is largely broken. okay? And it's broken for reasons that have been exposed in the Furman report, and also some of the things that Martin said, I think are very correct. And in digital markets, it led to the DMA, right? And in the UK, it will lead to the DMCC bill, and in Germany, it led to also Section 19 and these sort of things, right? So we know it doesn't work because it is a very slow instrument, it is a very heavy instrument, and very often the remedies arrive at a time where the patient is dead. So the remedial nature of Article 102 has largely gone away, right? And so what we need is something that the Commission may not want, which is actually a set of requirements whereby they need to get going, right? A complaint is filed, you've got 12 months to decide whether it should prosper or it should be sort of rejected. And then you've got a limited period of time during which you have to do a certain number of things. And I know I've spoken about that with Commission officials, but also officials in national competition authorities, and they hate it, right? They hate it for various reasons, which I can perfectly understand. And it's true, whether you're a complainant or a defendant. As a complainant, you know, look, I'm the complainant in the AdTech case. AdTech is 8 years of my life. I think you were involved also initially. It's still part of your life as well. Mm-hmm. And it's been a very long process going to the Commission. Commission is not interested, going to France. France is interested, but the remedies are not good. Back to the Commission. And then in June 2023, hoorah, there's a statement of objection, which is great. Congratulations to the Commission. They got it 100%. And then now it stops. Right, and we don't know whether, okay, it's going to be after the US decision, but the decision on liability or the decision on remedies, I don't know, but it's going to be many, many months. So it's very frustrating, very, very frustrating. As a defendant, it's not necessarily much better. Mm-hmm. Because sometimes you get an RFI and then another one, and then it dies for a year, and then you've got another one, and then, 6 months later, it hasn't progressed, and then suddenly there's urgency. You've got a short window to accept commitments or to do something, and then it fails, and then there's nothing happening for a long time. And so I think that no one really satisfied with the process. So I think if we want to really keep or resuscitate Article 102 as a useful tool, it's not the guidelines that will make a difference. They can make a marginal difference, but we have to think in terms of process. And I know it's very, very hard, and this is not what commissioners want to do, whereby if I were commissioners, I will not be a commissioner because I'm not a political creature and anything, and my country would not support me anyway. But if I were, I would actually really be process focused, because I think having done this for a long time, this is what matters. Now, I think Article 102, as applied by the European Commission, is in a post-remedial phase. Because it comes too late. But the decisions when they come are very important. Like, so shopping came too late. The bodies are dead, people are dead and buried, and if you look at what you have left is a skeleton that has been eaten away by animals, right? So, but I use Google Shopping every day in my practice because you've got self-referencing, which has now gone through the courts, and it's a very useful theory of harm if you want to challenge a certain number of practices. So I see essentially, Article 102 as applied by the Commission as principle setting, but not really helping victims, unless you use it to then seek damages, and then, the body's dead, but basically the family can get still something left. All right?
Maybe.
Now, Now, looking at the guidelines, I kind of like presumptions. At the end of the day, we will see what the court does with them, because you can presume anything, right? At the end of the day, companies will defend themselves and they will produce evidence. Whether it's good evidence or bad evidence, well, it depends on the cases, and then you go to court. Yet, I think they are important because they will mollify defendants. Okay? So if you have a defendant, you're advising a defendant, and you say, look, you've done this, right? And there's a strong presumption that it's illegal. Well, so the client will think, hang on a minute, what are my options? Well, your options is to fight it, but there is a presumption, or you concede and commitments are the best way to go. So I think with presumptions, you actually increase the likelihood of commitments, which is not bad, because commitments have a remedial effect that a decision after 6 years that's going to be appealed may not have. Okay, so that's for me one of the main merits. Just one word on economists. I know, Christina, we've discussed it before. I am more charitable than you are, although I'm most often than not on the complainant side. So you have an army of RBB and Compass Lexicon that will actually try to destroy everything you do and you've said. But complainants also need economists, right? So I'm using them, and filing a complaint without some economics around it, not the snake oil, all the incredible complexities with things that you don't even understand. That's not useful. But in terms of framing, and also in terms of analyzing the facts, I think it's useful to have some economics. But I agree that it can go wrong, and there's being use and abuse of economics. But I still like to work with economists essentially for questions of framing, much more than the data stuff. There are also cases where you can't do it without them, like auction stuff, ad tech. Don't even think that as a lawyer you can even scratch the surface of this thing. And I was at the CAT recently in our damages case against Google, and very usefully, there was a lady in the panel at the CAT who is an economist, and so she could actually challenge Google on their economics when they said, the auctions work super well and things like that. So let me stop here, and thank you very much.
Sure. Actually, what I suggest is to leave Max to say a few words, because he needs to leave, and then you will actually react to that.
No, you go first, because you need to leave.
Yeah.
No, I can stay.
Okay, great. So then Christine.
Well, I just wanted to be specific. I'm not having a tirade against economists generally. I've been an economist for 30 years doing this stuff, and so I don't think that all we do is totally meritless. Of course, framing is what we do. Thinking about the theory of harm is what we can do. But my issue, read the testimony of Mark Israel in favor of Google in court yesterday.
Sure.
That's what most of economics is about. So it's going up there and telling tales, and it's formulaic, and it is codified because we have a certain number of defenses. So it's not a diatribe against economics in general. There's perfectly decent people, but one needs to absolutely be very demanding about the arguments that are being put forward. And empirical analysis is notoriously fragile. We go in front of agencies and say, our analysis is robust. Guess what? Most of the time it isn't. Most of the time it is not. Empirical analysis is inherently fragile. So we need to accept it. Facts matter, yes, but internal documents, give me internal documents, I'll tell you what you were up to, not some sort of econometrics that nobody cares for. As final point, I agree that the issue is process. This whole thing is broken, as you say, but from the beginning. The case selection, we know, is driven by complainants. If you were to start about search, do you start from comparison shopping?
No.
Who cares? Who cares? It's an industry that doesn't care, that doesn't have a great future, doesn't deserve to live. I'm not going to defend them. Of course, today they exist as a collection vehicle to collect damages. That's all that these decisions are doing at the end of the day. But there is an issue of case selection, there is an issue of length, which is abused by both sides, because of course the Commission sends an RFI, and then you say, oh, I can't do a response in a month, and I need to respond in 6, and then the whole thing goes into a black hole. All the things you say are absolutely right. And which is why I think there is a bigger question, which is also linked to Draghi, final point, which is, I read Macho Draghi as saying, guys, whatever you're doing, it ain't working, right? Because the competitiveness of Europe isn't improved, isn't sustainable. And so, maybe in competition, you also need to rethink what you're doing. Go back to drawing board and rethink what you think you're pursuing.
Just one comment, not on that, but it's something I forgot to say, and it's going to take 30 seconds, is that I totally agree. We need something on exploitative abuses for the reasons mentioned by Christina, which is, with the concentration you have today, a lot of the harm comes from extraction, right? And by the way, if you look at the docket of the Competition Appeal Tribunal, when it comes to 102, I think about 75% of the cases are exploitative in nature, right? Because this is where you have the harm, the consumer harm, or the business harm. I'm not suggesting we need a section on it with the guidelines, right? And look, if you look at the DMA, there's a FRAND provision, okay? So the Commission is all around Apple, all around them, right? And I'm helping.
Don't call it.
Except on FRAND. Why? Because, and again, it's exploitative, it's extraction, it's what is fair, what is reasonable. But I don't think competition authority should run away from that, because this is where the harm is, right? So it's all good to think, okay, well, once you have alternative app stores, okay, good luck. And direct downloading, it's all going to go away, but it's going to take years, and with network effects, Apple will still be dominant and able to charge and discriminate. So I think competition authority should do better on exploitation. These are great cases on top of that.
All right.
I've said it all.
A few comments by Max, just to say that because the cat was mentioned, that I'm here in my personal capacity, personal views, that won't engage the cat. So, Max, yes, the floor is yours.
Yeah, and thanks a lot, Yanis, but I will abuse my position in the front row this time. And first of all, thanks a lot to all the speakers, because I found this panel super interesting, and we got a lot of good input, and we've been taking a lot of good notes. So thanks a lot to everyone. I will not react on everything, just on 3 points. First, the value of Article 102 in today's world, which is something that is very close to my heart, and I fully understand your points of view, I understand the frustration, I understand the comments where you're coming from, I take it. First of all, yes, it is of course also about process. I fully agree, and there is a reason why we have recently concluded an evaluation of Regulation 1. It's too early to say what we're going to do with that, but of course a big part of this is about process, and the Commission is certainly not closing its eyes on that side. The precedent value is extremely important, because once we have a case and once we win in court, and that is not easy, and of course one part to choose a case is also the likelihood of winning in court, and not only the fact that we have to be relevant, we have to make cases in fashionable industries, all of that I see, but we have to make cases that are strong, because once we have a strong precedent, then we can move on and look at the next frontier. So that is something which is very important, and I understand that it's very dry and practical, but on the other side, for an enforcement's perspective, it's something which is key. And then the last point, of course, I see that the criticism is, oh, now we need the DMA because Article 102 is broken. Yes, but on the other hand, also the opposite is true, that without Article 102 and without the experience that we have gained thanks to the enforcement of Article 102, we would never, ever have had the DMA. And it is not a coincidence that we have the DMA in Europe, where we had an exponentially larger amount of enforcement in the abuse of dominance field compared to other continents. So on that point, I'm closing. 2 very quick points on Judge Ball's comments. I didn't take it as particularly pessimistic. My interpretation of it was, why do we need these guidelines? Because the case law is confused, and it was perhaps a way to indirectly criticize some of his former colleagues, because in his view, they were going in all direction with their judgments. I'm not saying that I subscribe to this view, but that's the way I read it. He even said that draft guidelines did a quite good job in reflecting the state of the law. So I didn't see him as criticizing too much, but maybe it was me. And the very last point, competition on the merits versus effects. Frankly, after Google Shopping Grand Chamber and Super League Grand Chamber, I really struggle to see how we can say we should look at Google AdSense because it says something different. That being said, we're going to take this home and reflect, but you have two Grand Chamber judgments which say one thing that I think is very clear, and that is, of course, something that has to be taken into account.
All right, so I just want to give the floor for no more than a couple of minutes because we need to start the next session at 4:30. Anna Sophia, your comments,
Thank you.
reactions. Yeah.
Johannes, it has been very interesting to listen to the others. My first point is that I think we should and we must keep committed to enforcing 102 vigorously. Otherwise, it will be a self-fulfilling prophecy. So if we lose faith on an instrument which is in the law and that it is for us competition agencies to apply, then we're not doing our job, and this is a self-fulfilling prophecy, as I said. And I also speak as somebody that is behind the trenches for a long time. And behind the trenches means that sometimes we need to be proactive, I think. And this is something to which we have devoted a lot of thought at the agency. And why? There was a moment many years ago in which the Portuguese Competition Authority was receiving no leniency applications, almost, right? So we were in a very bad spot. That meant that we had to have a very proactive strategy in order to foster. If you don't have a proactive strategy, if you don't show up, then there's no complaints, there are no leniency applications. So we went out there, we had a lot of advocacy campaigns, and last year, or a couple of years ago, last year actually, we reached our maximum record in terms of leniency applications. Now, we feel the same regarding 102. There's not a lot of complaints we receive, which means that we need to be proactive again. In the past 5 years, we have about 4 cases of 102, 2 of them sanctioning decisions, and those 2 are the outcome of ex officio. One was a full ex officio exploitative case. It's interesting to look at the experience of national competition authorities in terms of exploitative abuses. This is a very interesting case in which it was a capacity limitation. It was full of economic analysis. We had long-lasting sessions in court with both sides presenting evidence, highly technical. It was in the energy sector. And what was there probably one of the elements that made the difference was that the court, the judge, was assisted by an economic advisor that was chosen with highly and strict independency criteria. Because, you just want to have an economic assistant to the court if it's an independent, and otherwise it's better not to have. No, right? Anyway, in this case in particular, there was this is res judicata, so it was confirmed through first and second instance court, and there the parties were arguing that in order to have a case for limitation of an exploitative case based on limitation of capacity, you needed to demonstrate the same criteria and the United Brand criteria that you have for excessive pricing. And the judgment of the court is absolutely clear in that you do not. So I think these are interesting cases to inspire us. Then the second case that was more recently decided and was fine in the payment services sector, again, was opened within a market inquiry in which the agency perceived that there was less competition in that sector and had a perception that there were competitive bottlenecks, and engaged with stakeholders through questionnaires that were sent, and this was what led then later on to the case. So I think it is very important not to lose faith and to be creative and try to think about ways in which we can make 102 enforcement. Also because, as Maximiliano was saying, I think it's it's what informs regulation. It happened with the DMA, it happened in the past with telecoms, it happened in the past with energy, so I think it's very important. And the last point, to second the example that Damien mentioned earlier on, which sometimes a small sentence in guidance can make the whole difference. Damien was mentioning labor markets and the possibility that non-competes in markets where there's scarcity for labor, in which you cannot train and train the labor force very quickly, can be used in order to deter entry or to foreclose existing rivals. And I think that just a sentence like that can be eye-opening, like you had in the horizontal guidelines with the no poach. Just the fact that it's there can lead to more complaints or can be lead to further action on that. Thank you.
No, thank you. So, Christina, would you like to have? So let's move to Martijn. Any comments? Or
No.
Oh, yeah.
I said my piece.
Yeah.
Me too.
Maybe one quick comment, also from a different perspective. Not to say that I've lost faith in 102. No, but at the same time, I think we also have to accept that the fact that we have a tool does not necessarily mean it's the right tool. It was drafted 75 years ago. The world was completely different. We had different problems. It was an EU tool, and it was the right tool for that moment. And I think what I like about Draghi's report is that it sends us back to the drawing board says, maybe we have to think about other tools. And yes, I understand it's extremely hard to change a European treaty. So we'll probably have this tool for a long time, and that is good. But thinking about adding a tool that is more attuned to the issues that we are now facing, building on the experience of the last 75 years, would be a worthwhile exercise.
Can I just say now I've got something to say. Because I want to, one second. I want to really underscore this, because I think we are in a different era. Guys, we all started, or many of us started competition 30 years ago, and it was a bubble, and it remained a bubble. It's a different world. What Draghi is saying is precisely that. Go back to drawing board. Step back. Where is Europe? Nowhere. We have a lot of trouble from the perspective of growth, productivity, and so on. What is competition policy as an instrument of economic policy doing to essentially enhance the position of Europe? And so work together with industrial policy and trade and all that. We need to just step back from this bubble and kind of getting worried about the word and what does that mean. It's kind of so maddening. I don't know, I just think we're in a different world. Wake up.
Comment, Damien, on my right. I don't know, you have anything else?
No, just 2 seconds. I like the new competition tool.
Yeah.
I like it, we need it, and I was sorry it didn't go through, but it's never too late.
Damien?
Well, you can quote me on that. Just two very short comments. Obviously process is super important. In Belgium, for example, we can settle 1 or 2 cases.
Yeah.
And we have, and thanks to Jacques, we have a great practice of imposing interim measures.
Yeah.
And so I think these are really, really helpful tools. Now, again, to echo something I said before, you win a 1 or 2 case on the facts.
Yeah.
And so it's all about finding the right evidence. And I fully agree with Sophia, is that we need to be more proactive. And frankly, I mean, in a few cases, I've been asking myself, well, why don't we carry out a down rate in a 1 or 2 case? I mean, why? We never do it, or very rarely. We very rarely do it.
You should start.
Yeah, no, exactly. I mean, this is really about finding the right evidence, and once you have it, you see that everything changes obviously in the interactions you have with the parties, and you can get to a solution quite quickly. Obviously, also something that everybody should be aware of is that all the cases that are decided by competition authorities, I mean, they're the tip of the iceberg of what we do. We actually solve a great many cases without even having to open proceedings, or at least by not having to go to the end of the proceedings, and by smartly using the different tools we have, including amicus curiae, briefs, etc., etc. I mean, so that's still important to keep in mind. And the last point, obviously we live in a different world, and that has, obviously exploitative issues are extremely important, and so I think we should also think about institutional changes, and I mean, I think Martijn and others have paved the way in combining competition enforcement and consumer protection, But frankly, I mean, I'm increasingly convinced that this is something we should also do in Belgium, and that we should do probably in other countries as well, if not systematically, because that's the only way to actually have an effective action on many practices which are inherently linked to the evolution and the digitalization, in fact, of services and society in general.
Well, thank you very much. That was, for me at least, a very enjoyable panel, a discussion with former colleagues and actual colleagues. So thank you. Please listen to speakers. Let's move directly to the next panel. So I will ask you to kind of pick your glass, green glass, and sit around me. Just to also note that I think the issue about process is absolutely a good point. And maybe that's also motivating the fact that we are thinking more about the new competition. So this is a little bit about the idea that the code-based approach in competition law is somehow